83. There is an objection to all three. Is that correct, Mr. Kinsey?
Yes, Your Honor.
Okay. So Exhibit 83 contains text messages between Miranda Goddard and Jimmy Shelton for a period from April, they go back from April 17, 2017 to 8/16/2018. And I've reviewed that document. General, what is the probative value?
The state's position of probative value is simply that the defense has submitted that Jimmy Shelton was victimizing Miss Goddard, that he was this monster who has continually victimized her, and that she was the victim of a rape and molestation as this was going on. The text messages show a perfectly normal relationship wherein Miranda is obviously very consensually friendly with Mr. Shelton. She's not afraid of him. She's not worried about him. He's not tormenting her. He's not some sort of batterer that's always trying to bully her around and force her what to do. And since the state believes that's what the defendant has set out in his opening and is through his cross-examination of witnesses, that's why the state finds it to be probative, just to show that the relationship was not some crazy, hidden, sexual, devious thing. The text messages are just perfectly normal stepfather-daughter conversations.
And how are they not hearsay?
Yeah, they're not offered for the truth of the matter asserted. What's in them is not going to say what they said is true. That's not why we're offering them. They're not for the truth of the matter asserted at all. So they would be non-hearsay. I'm not asking that what they're saying proves any fact in question.
Mr. Kinsey, do you want to respond?
I would say, given the state's response on that, I would say it's bolstering what they've already put on with Ms. Goddard's direct testimony.
Okay. All right. Then I have reviewed the proposed text messages contained in Exhibit number 83 that's been marked for identification. In review of those text messages that go back to 2017, the court has several concerns. Simply, the state's witness, Miranda Goddard, has already testified about the nature of the relationship between her and Jimmy Shelton. As far as these are text messages between the two of them, the probative value upon the review, it doesn't seem great in weight of the other evidence, and really is just a sort of a backdoor to bolster what has already been the testimony. And therefore, based upon the objection, I am going to sustain and not allow Exhibit 83 as far as the text messages between Miranda Goddard and Jimmy Shelton. Miranda Goddard and Sean Foley. Do you have an objection to those text messages?
Your Honor, at the moment I believe they're irrelevant. I don't think they have anything to do with this incident at all. I mean, I think they, on a sliding scale, there's whether they make a fact true or not true in this case, I don't believe they do, so that would make them irrelevant.
So how are they relevant?
Again, the state's position and the whole setup that Mr. Foley is some sort of savior hero that saved Miss Goddard from this molestation, alleged molestation that was occurring. That there were, and I take them in conjunction with the text messages of the other two contexts that relationship. If anyone has a sordid relationship, the state's position it would be Miss Goddard and Mr. Foley, and that those text messages would set that out.
But how are they relevant to the incident that we're here about today?
Because I believe the whole defense centers around what was going on that porch, who was afraid of who was worried about who was in fear of who. So that's the state's position.
And based upon the rules of evidence and the court's review of these text messages, I don't see how they can be directly linked to the incident that we're here for today. I don't see that their probative value outweighs the prejudicial content. Several of these have already been testified to as well. There's nothing in here that really hasn't already been testified to by Ms. Goddard. as far as the nature of that relationship. So I'm going to sustain as to 82 and 81 marked for identification. That's the text messages between Sean Foley and Jimmy Shelton. They are short in nature, from August the 20th, 2018 to August the 28th, 2018. They basically are about what has been already brought out in the proof, that it is about making arrangements to stay there while Miranda Goddard, so that he can be there when she's released from custody. That's about it. So let me ask this, Mr. Kinsey, do you object to those messages? The ones between Mr. Foley and Jimmy Shelton?
No, Your Honor, I don't.
Okay, so without objection, then 81, it's marked for identification now. However, you may question the witness about exhibit number 81. Okay, all right.
Would that be, I guess, it's ID 81, does it come in as actual 81? Okay. I know they have different color stickers.
Right, do you have any objection to it going ahead and being admitted? Okay, the detective has already testified as to how it was extracted from the phone, but you can ask for immediate evidence in front of the jury. Okay. All right, let's bring the jury back. All rise. And we are going to discuss jury instructions. Please be seated. Note for the record that all 16 jurors are present in the courtroom. Were there any violations of the court's admonition? No. Any consultation of outside sources, any independent investigation, any deliberations or discussion amongst yourselves about the case? No. Are all of you ready to proceed? Yes. Please continue, General.
Detective, we had mentioned one text conversation, or the group of texts between Mr. Shelton and Mr. Foley. Were you able to retrieve those text messages?
Yes, sir.
And you recognize this extraction report from the cell phone extraction?
Yes, this is the text messages between Mr. Foley and Mr. Shelton that came from the cell phone.
All right, this is coming as exhibit number 81, please.
No objection.
What received into evidence is 81.
And I won't make you read every single one of them, Detective, but that didn't work. In short, is there anything, what is the nature of the conversations between Mr. Foley and Mr. Shelton?
Just general conversation about Mr. Foley coming to their residence to stay until Miranda gets out of jail.
Okay. Is there, at any point in any of these conversations, do you observe any threats?
No, sir.
Do you observe any conversation at all about any alleged history between Mr. Shelton and Ms. Goddard?
No, sir.
I do want to ask you, the last text message that was sent between the two of them, what was the date of that text message?
The last one was August 28th.
Of 2018?
2018.
And that was the day of the shooting, correct?
That's correct.
And what time was that text message?
3:48 a.m.
And what does that text message say?
It says, "Can you tell Miranda I need to smoke? I can't ski."
I'd assume that may be sleep.
Sleep is what I would assume.
So Mr. Foley had texted Mr. Shelton the morning of the shooting.
That's correct.
And again, just a fairly benign text, would you say?
Yes.
Thank you. Detective, we also heard on the recording a statement by Mr. Foley regarding his military service, correct?
That's correct.
Did you do any investigation into that?
I did. I contacted the Veteran Affairs Office and asked for his DD-214.
You recognize this certified copy?
Yes, sir.
Is that the DD-214 you received from the Veterans Affairs Associate, whatever it is?
It is.
I ask this coming exhibit number 83, please.
Any objection?
I would object to it, Your Honor. May we approach?
Yes. We can mark it for ID purposes, be 84, correct? Okay. Sustain the objection. Actually, can you both approach again, please? Okay, please, you can continue.
Your Honor, at this time, I don't believe the state has any further questions.
Okay, Mr. Kennedy?
Detective Carswell, when you arrived on scene, you testified that there was a female witness that was in the car, in a police car. Is that correct?
That's correct.
And that was
Miranda Goddard.
Thank you. You made your way through the front yard
Correct.
and around the Toyota pickup truck that was sitting there,
To get to the back deck, yes, sir.
and so you rounded the back deck. Were you taking pictures at this time?
No, sir.
You didn't take any pictures at all?
No, sir.
So you observed, were you able to observe the drink that was sitting on the, in the orange cup right on the edge of the porch?
Yes, sir, I did.
Okay. You observed the chairs that were sitting on that right side of the porch?
I did.
Okay. Neither of those chairs were disturbed?
No, sir, not the two against the house.
And so when did you proceed onto the deck at that point?
As I'm doing my walkthrough?
Yes.
Yes, sir.
So when you proceeded onto the deck, you noticed the hose that was curled up you described.
Correct.
What color was that hose? Do you recall?
I would need to look at the pictures to be certain.
Okay. It's not important. I was just curious if you recalled. And it was green. I didn't mean anything disrespectful about that. In the middle of that curled up hose, there was a holster.
Correct.
Do you recall what kind of holster that was? I mean, as far as was it a concealment holster, or was it an external holster? Do you remember?
I believe it could be, it's the kind that you wear on a belt. You put belt loops,
Okay. And
belt through.
did it have a clip on it so you can clip it on your pants too?
Not that I recall.
Okay. You described earlier shell casings that were on the porch.
Correct.
And those shell casings are all in evidence.
That's correct.
Is that correct? Each of those shell casings were where on the porch?
The ones that were on the porch were all above the victim's head.
Okay. So that would be on the end of the porch near the doors, correct?
Correct.
Okay. And does that... You've been an officer and a detective for some time, correct?
Yes, sir.
Can you tell us, based on your experience with in being a detective and as a police officer, can you tell us what normally happens when a gun is fired, specifically with the spent casings?
On this particular gun, the shell casing is ejected out to the right.
Okay. And all of these shell casings were on the right, is that correct? On the right side of the pantry door.
Correct.
Okay. Were you able to discern how far those shell casings had flown?
No, sir.
Okay. And did you observe the bullet hole that was in the deck?
I did.
Okay. And were you present when the rod was put through the hole so you could see the angle and all that kind of stuff?
No, sir.
Okay. Did you note the angle, or?
I know the crime scene investigator did.
Okay. Are you in charge of the crime scene investigator?
No, he has his specific duties.
Okay. Do you recall how far that bullet hole was from Mr. Shelton's head?
No, sir, I don't have those measurements.
Okay. You interviewed several people in this case, correct?
Yes, sir.
Okay. You interviewed Miranda Goddard, is that correct?
That's correct.
Okay. Did you record that?
Yes, sir.
And have you requested a transcript of that recording?
Yes, sir.
Okay. And did you turn that transcript over to the district attorney's office?
I did.
Madam Bertrand?
Yes.
Detective is on top. Is that the transcript request?
Yes, it
that you
is.
submitted? And the next page, does that appear to be the transcript that you requested?
Yes, it does.
Your Honor, for ID purposes only, Exhibit 85, the ID.
Identification, any objection?
Not for identification.
So, identification 85.
Nothing further at this time.
The redirect, Your Honor.
You may step down.
Your Honor, at this time, the state of Tennessee would rest its case in chief.
Would you both approach, please? Okay, for the purposes of the record and for members of the jury, I received a question that I have marked J. The court has reviewed that question and spoken with the attorneys, and that is not an appropriate question for the last witness, and so it will not be asked. All right, I'll have to send you out for a moment. The state of Tennessee has rested its case. I need to speak to the attorneys for a moment, and I'll bring you back in. All right, all rise. Please adhere to all of the court's admonitions. Please be seated. The state of Tennessee has rested its case. Mr. Kimsey.
Your Honor, if I may I have 30 seconds?
Sure.
Drop down some notes.
Yes, sir.
I believe is your microphone off, ma'am?
Okay. Is it still not on?
It's flashing green. I don't know what that means.
Why is it going up to talk to you?
No, I'm not.
Okay.
Gotcha. All right, I'll hear you.
Thank you, Judge. Your Honor, at this time I move for judgment of acquittal on first-degree murder, on the count of first-degree murder. Your Honor, first-degree murder requires the intent, the premeditation element. Your Honor, at this time I don't believe that the state has put on evidence of premeditation. They've said it. They've said it many times in opening. 22 minutes and 47 seconds. He sat there, laid in wait. Judge, I believe that the evidence that it was actually shown was not that he was laying in wait, that he was recording. Judge, I don't think that element of premeditation has been met by the state. On that, with that, I'd move to dismiss the first-degree murder count, putting it to the jury as second-degree murder and remaining counts.
Thank you. Do you want to be heard, General?
Your Honor, as this court is well aware, in a motion for a judgment of acquittal, the court is to review the evidence in the light most favorable to the state at this time. I respectfully disagree with Mr. Kimsey's assertion. There are several factors that can be used that are set out in case law for premeditation, the procurement of a weapon,
the shooting of an unarmed person, a reaction afterwards, whether it's calm or just the nature of the defendant's reaction, a profession of an intent to kill. Respectfully, the state would submit there's proof of all four of those in this particular instance. So there are certainly factors for this jury to consider when it regards to premeditation, intentional. I don't think there's even any argument that this was an accidental shooting, that it was an intentional shooting, and there are multiple factors present. The proof is provided to show premeditation. So respectfully, the state would put that there is more than enough evidence for this indictment as charged, first-degree murder premeditated, to go to this jury.
Thank you. Final word, Mr. Kennedy? Okay, at this time, based upon the close of proof by the state of Tennessee, the defendant has made a motion for judgment of acquittal as to the charge of first-degree murder that is contained in the indictment. As correctly stated by the general, at this point in the proceedings, the court is directed to consider the evidence in a light most favorable to the state. There are several factors to consider in determining whether a case can be submitted to the jury for premeditation. And the case law is replete with different factual scenarios and different issues that can be proffered to sustain first-degree murder. The general has cited several of those, including the procurement of a weapon, killing of an unarmed individual, the reaction time after, or the reaction of the person after, intent. One of the other issues is, did the person lie in wait? And while that is definitely in dispute at this time, the standard which was the court must consider the evidence. At this time, I'm going to deny your motion for judgment of acquittal and allow the state to continue with the indictment as charged as to first-degree murder through premeditation.
Yes, ma'am. If I may, Judge. Next, I'd request I guess we were going to talk about jury instructions.
We're going to do that at the close of all the proof.
All right. What I was going to ask for is the self-defense instruction. Judge, we had previously spoken about that. What I was going to ask for is a ruling on the self-defense instruction now. Based on the evidence that's already been presented by the state. The 911 recording where my client claims to have been rushed. The firing position on the porch, location of the victim. MB's report discussing distances between the victim and the MB's testimony today, between the shooter, the distance from the shooter to the alleged victim at that time. The bullet angle through the porch, Your Honor, which is in evidence as well. All those things, I think, indicate that Mr. Sheldon did, as evidence on the recording, rush my client, so I think that is enough for self-defense at this time. I request the court to make a ruling on whether that burden has been met, to fairly allege.
General?
Does the court want to hear that now? I can respond.
Go ahead. And I guess I would ask, are you requesting a determination on that before you present your case?
I am, Judge.
Well, if the court is going to determine it now, the state's position, quite candidly, is as a question of law, self-defense in the state's mind is inapplicable here. The law is quite clear that self-defense does not apply wherein the person who is alleging self-defense created the deadly situation, is the instigator, is the aggravator, is that person. And the state's position is going to be that the proof is very clear that it is Mr. Foley that created this deadly situation, that he is the instigator, that he is the aggravator, that he is the one who pointed the gun, introduced the gun, and pointed it at the person. If self-defense goes to anyone, it would be Mr. Shelton, will be the state's position. And that self-defense, that he doesn't have any right to claim self-defense because of the actions he took that led up to the shooting. That is the state's position, that as a question of law, based on the case law that we have reviewed, that we had cited, I think, in our request for a special and jury instruction, should the court decide to instruct on self-defense, that self-defense simply cannot be claimed in this because of what Mr. Foley did that led up to this shooting. That would be the state's position, respectfully.
Mr. Kimsey?
I would agree that the state's position is a question of fact, and whether Mr. Foley did create this situation or whether Mr. Sheldon did, which is a question for the jury and their providence.
Okay. You look at the jury charge on self-defense. Give me just a moment. All right. Have you each told, because I provided with you earlier, it is 1, 2, 3, 4, 5 pages, what the court has previously submitted to you as part of the jury instructions. I'm going to go pull a case, and I'm going to read those 5 pages. I would ask that you review that as well. There are several places that are bracketed that I'm going to speak to you about momentarily. Court's in recess. In the meantime, Mr. Kimsey, I'll need to know about the Momon hearing as soon as we return.
Yes, Sean.
This should give you an opportunity to make a decision there.
Yes,